Hello, my true crime lovelies. How are you? I hope you are well. I hope you can hear me. Oh, there, it's better. We're going to talk about Lori Vallow Daybell today. The last time she was in front of a judge, this is what he was giving.
All right, are you done?
In that hearing, she asked him to recuse himself, among other things, among arguing with him about every ruling that he made. Yeah, so she's going to be in front of a new judge in this video. But before we get into that, let me thank the members and everybody who buys me a coffee and all of you who are just here and share a little bit of my family with you. Okay, so really quickly, Lori has escalated getting Judge Bowerski, Judge Smoldering, recused, right? So she had that argument with him. She went on a rant about how he was biased, and so now she's escalated it to the chief. I think it's the chief judge, might be magistrate, whoever is over that court house. She's escalated to that. And also, before we get into that, I will say, in another hearing, and this is going to be not long. I can't cover all the hearings that I missed, so I'm just trying to hit like the high points. In another hearing, the judge said he would not be ruling orally on motions anymore. He would reduce it to writing because the last time when he was dunning her several times, she was arguing with him. So he does it. She can't argue with the paper. Well, she can, but we won't have to listen to it. You know what I mean? So that is that situation. And then one more random thing in our members live, someone was asking why won't they be including the footage of Lori in Idaho in the storage once, or at least once with Chad and once with Alex, with the tire and other things, because they're not allowed to enhance it for court. And I guess it was very, very grainy. What we saw on East Idaho, Nate said he had refined it, right? So yeah, that's why, if anybody is wondering, that's why that's not coming in. Okay, let's get into this. Her in front of the Grand Poobah. And it's this, speaking of grainy, is going to be a little bit of grainy. When this was announced, I guess there was not enough time to get a camera into court. So they're using the internal court recording system, which I believe is called JPR. Don't quote me on that, but let's listen in.
2022 00124201. This is State versus Lori Daybell. Appearances, please.
Tanika, on behalf of the state, and for the record, the victim is appearing virtually.
Thank you.
Lori Daybell for the defense. Pamela Hicks, Advisory Council.
Thank you. There was this got set very quickly. There was a media request that I became aware of in passing, literally on my way over here. I don't have a written request. I have not read all my email because I've been on the bench this morning. Do you want to make a record with regards to the media request from the state?
No, Your Honor.
Okay, from the defense?
No.
Okay. I don't see anyone here. I thought we would address it on the record, but I don't see anyone present from the media. Okay, I assume there's no objection if they come in. Ms. Kay?
No, Your Honor.
Ms. Daybell?
I always object to them, yes.
Oh, you object to them?
Always.
Okay. Is there anything you wanted to put on the record?
No.
All right. My thought is if they come in, we can address it. All right. The court's, this is the oral argument on Ms. Daybell's motion for change of judge for cause. The court's in receipt of and has reviewed motion to disqualify judge. This was filed.
Not sure if you heard her, but she said she always objects. So clearly they didn't come in because we're watching it this way. But I guess if she did object to it being posted this way or shared this way, it was overruled, right? Because here we are.
On May 20th, and the state's response to defendant's motion to disqualify judge. Ms. Daybell, I've read your motion. In summary, the way I read it, you're asking for the court to remove Judge Boreski for cause under Rule 10.1. You cite several reasons, specifically that he's denied various motions. You mentioned facial expressions. You mentioned a belt and his not allowing you to remove it. You assert that he violated your speedy trial. There's a mention of religious persecution and an allegation of personal bias. So you're going to get, and then the state's response is that simply the defendant does not establish judicial bias, appearance of bias, or fundamental error. Of course, under Rule 10.1, the court is evaluating whether or not Judge Boreski can be fair and impartial and whether he can conduct a fair and impartial trial in this matter. So I'm aware of the allegations. You'll have the opportunity to go first, then I'll allow the state and to address the court, and then you'll have the last word. Whenever you're ready, Ms. Daybell.
I did file this motion in
Ma'am,
this.
I'm sorry, can you pull the microphone? I'm sorry, can you hear me? Thank you.
Sorry. I did file this motion in this affidavit after several attempts to. I made an oral motion with Judge Boreski and asked him to recuse himself because of the bias and prejudice that I had seen during our last trial and throughout the whole entire time that he has been the judge over all of these cases. And he refused to do so. So I thought I needed to put it in writing and put all my points in that I felt like were causing him to be biased and prejudiced against me, and that obviously you've read it, so you've seen all the different things that I put. There was an actual comment during trial when I was cross-examining one of the witnesses where he said to me directly after an objection from the state that I was comparing myself to biblical prophets, which I absolutely was not doing. And I didn't even realize it until someone showed it to me on the FTR afterwards that he had even said that, because I was in the middle of questioning the witness. And
Oh, maybe this thing is called the FTR and not the JPR, whatever that is. It's the internal. She is twisting words here. I believe what he said was, if memory serves, to the extent you're comparing yourself to biblical whatever, I'll let you go ahead. Which, isn't it when she's saying in writing, I shall be like Nephi, and so will you? If she is like Nephi, English is, it's been a minute since I had a class, but if she is like the word like, isn't that a comparison? Isn't she comparing herself to Nephi? So, and to that extent, he let her go ahead, but she is now saying something else.
so there's several times that he made comments directly to me. I tried to address this with him directly in our last hearing on May 14th, where.
And when she's saying she tried to address, that's the sort of bickering that we saw in the last one. She did not cite any case law on what grounds she was making that. Like, she didn't say, that should not have been allowed because of blah, blah, blah case that was heard by the appeals court in Arizona. You know what I mean? Like, all she did is she just blurted things out. And it was all emotional because first she said, you never, or you always deny. And it wasn't the case. And then he said, I just approved you having a wherever going in the back with your advisory council. So then she was like, well, you mostly. So it's her talking in that sort of hyperbolic way. But ma'am, where is the case law? Also, there is nothing in the law that is like says you have to keep score. If in fact it is true that he never did, which we know it isn't, because then she conceded that it wasn't. They're each standalone for the defense and the state. It's a standalone. It's not like a zero sum where you're keeping a tally of like one love. She's got none and the state has one. Do you know what I mean? It's on the merits of each individual motion that he makes the decision, irrespective of which side it was. So, and he made the point, you haven't made any that have, or not that you haven't made any. Now I'm assigning hyperbolic speak to him, but he was like, if you submit a motion that has, some validity, basically, I might, accept those. I might approve, agree. not deny.
I asked him why he had denied every single motion that I had ever filed in the last year and a half. And he said that my motions had no merit.
So, see, she skipped over. She kept in the every single motion instead of most of them or the majority of them. He disproved the every single motion in real time with her.
I asked him if my prior defense team, that he denied all of their motions, that they had no merit as well. And then I asked him, my prior defense team before that, all the motions they filed were denied, and did they have no merit at all either? And I asked him again if he would recuse himself from this case so that I could get a judge that was impartial and fair and have a fair trial. That is my right, my Sixth Amendment right and my 14th Amendment right to have a fair trial, an impartial trial. And
you know you're in trouble when you're going way over to the Constitution to get help. Can we stick to the local, the state laws, the precedent? Like, what are you basing this on? How are you substantiating that he's not being impartial? What demonstrates that? Do you have a specific motion where you laid out case law and he still denied it? And if so, why aren't you appealing it in the case that it happened? Why are you carrying it forward? Do you know?
Not a judge who has some kind of bias against me.
All right, anything else? Thank you.
Judge, just the prior defense motions almost all exclusively dealt with motions to preclude the media. Judge Boreski applied the appropriate law in finding that the media had a right to be present and tried to limit it by saying things like they couldn't focus on the defendant's papers or things like that to mitigate any of the concerns by the defendant. All of the defendant's motions that she has filed have been without legal basis. They've been appropriately ruled on, and the state's motions that the state has won have been ruled on based upon, again, legal basis. So the fact, as the court is well aware, that the defendant has had all of the motions ruled against has no basis for bias if they're all been ruled on based upon the rules of law and the rules of evidence. So we see nothing that the defendant has provided here that would rise to a level to preclude or recuse Judge Boreski from this case.
Thank you. Ms. Daybell, you can have the last word.
Yes, also, along those lines, Your Honor.
Her sweet voice is back.
That's one thing that I asked Judge Boreski, is that he has denied all these motions with no finding of fact and no conclusion of law. I said, what is the finding of fact and conclusion of law? These are just denied, 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 denied. He's also denied several attempts for me to try to ask.
But to be fair, if she's not citing any case law, does he then in turn have to dig up case law for her to help her build a better motion next time? Or can he just follow suit and say no? Like, he doesn't, there's nothing that she's provided where he can add context of like why this doesn't apply or why part A of this might apply, but because of part B, he's denying it. Do you know what I mean? Or am I giving him too much credit?
The state for discovery that he's just denied outright. And then as I
go back, I'm sorry, I talked over it a little bit.
He's also denied several attempts for me to try to ask the state for discovery that he's just denied outright. And then as I keep filing more and more, as I find out what we don't have and I ask for it, I'm continually, even to last week, getting brand new discovery with brand new Bates numbers, stuff that they realized they never even had before that hadn't been turned over. And I've been asking Judge Boreski for these items for.
If they never had it before, how can they have turned it over?
A year and a half. And I'm getting them 1 week before trial. We start picking our jury today. We're supposed to be doing our strikes today. And along those lines, I had this motion about the RAC belt that I had asked him about since we went through this whole trial. And there was times when the belt didn't fit around me, so it fell out of my clothing. We had to.
So there are ways to remedy that other than removing the belt entirely.
Stop trial, and I had to go fix it. And that is what MCSO recommended, that if that was too burdensome, that they would put an armed guard in the back.
It's not too burdensome, though. Who is it too burdensome for? The jury didn't see it. You were not impacted by it. The trial was not impacted by it. And did it happen again after that, or are they securing it in a different way? Is that really a problem? It feels like the problem is she doesn't want to wear it, right? Because she said that going into the trial. And so it just would make sense that she's going to find problems with it to support her not wearing it.
And because of the media that Judge Boreski has let into every single one of the hearings and the trial, that they already have an armed guard back there. So it wasn't going to cost the state any more money. It wasn't going to cost anything if he just had them remove the belt and went over the security that the MCSO actually recommended.
Also, that she's misquoting the recommendation. The judge repeated it to her, reread it to her several times. Yeah.
Every single thing that I asked for has been denied. I feel like he does have a personal bias against me. And all I'm asking for, I went through a whole trial with him, even thinking he was biased against me before the trial started. I filed for a new motion because it came to our attention through the media. The media sent Judge Boreski a clip of one of the jurors saying that he found out about my prior convictions beforehand, before his deliberations. And this is the same exact juror who was brought in twice during trial by Judge Boreski, where he had to admonish him for, one, being on his phone, and two, talking to one of the other jurors about the case. And now he's saying, well, he went on another media thing and said that he took it back. He took back what he said. So I'm not going to give you a new trial, and nothing was done about it. He refused to call them in and have a hearing and put him on the stand under oath and ask him if he found out this information prior to deliberations. It was very confusing, and everything is just outright denied. I want to go to trial. I want to have a fair trial, as fair as possible. I don't feel like I can do that with.
She is not giving this judge anything substantial to substantiate that the judge ruled out of partiality. Like, you didn't bring in a case law that said, I asked for this. Here's the document about the belt where this is what the recommendation is. Here are the transcripts from what Judge Boreski said. And there is a disconnect. He's overtly choosing to go against. I mean, ultimately, it's his courtroom, so I don't even know if he has to defer to these people. Maybe that's guidance once they're in the courtroom. I feel like they have to have some sort of like handshake, handoff, whatever, because they're the ones keeping the courtroom safe, right? And that would be their jurisdiction, but it is the judge's courtroom. But she's going so hard on this belt with like, no, this judge is just hearing her word, and then she already heard Trina K's word. Trina K is an officer of the court. Lori has nothing to substantiate what she's talking about. She's not making it easy for herself.
Judge Boreski, and I would like to be appointed a new judge who wouldn't know anything about the case and be fair and as impartial as possible. Thank you.
Thank you. I've considered the written motion and the response, and certainly your comments today from both sides. Ms. Daybell, I find that the fact that you disagree with Judge Boreski's substantive legal rulings is not a valid basis under Rule 10.1 to
substantive legal rulings versus her I hear house shoes coming.
To grant your motion and give you a new judge. The standard in 10.1 is, has he demonstrated he can't be fair and impartial? And the fact that his rulings have not gone your way is not a valid basis to suggest that he can't be fair and impartial. Unless there's some other allegation of bias that's been demonstrated. I don't find on this record that it has been demonstrated. I certainly understand your frustration with the way that the rulings have come out, and it sounds like the way that they came out with prior counsel. But the things that you have cycled through at length in your motion to disqualify, I've considered all of them. Whether or not he should have ruled differently, for example, the example you gave with the juror, or with making findings of fact and conclusions of law in writing, some of the issues you have, if you have concerns about his substantive legal rulings, you can file a motion to reconsider, or you can take them up on appeal. You can file a special action. You have a number of legal remedies at your disposal where you can make those arguments, but they're not grounds under Rule 10.1 to get a new judge. So I am going to deny your motion. Again, as for your concern about his
Denied.
substantive legal rulings, you can address those concerns in a different way, but it would not be under a 10.1. And on this record, I don't find that he's demonstrated that he can't be fair and that he can't be impartial. I also wanted to address the comment that he made that you illustrated. That comment alone doesn't demonstrate that he can't be fair and impartial. I'm not exactly sure of the context where he made it, but it sounds like he let you ask a question with regards to religion, and that was his decision. But again, I don't think even that demonstrates that he can't be fair or impartial in this case. All right, so I'm denying the request to disqualify Judge Boreski under Rule 10.1. Is there anything else from the state?
No, Your Honor.
Anything else, Ms. Daybell?
Nope.
Thank you, we are adjourned.
Round 2 of Lori's Arizona case.
I think the interesting thing about that last bit about the religious persecution that the judge addressed, it's clear that he ruled in her favor because she mentioned that there was an objection and she wasn't paying attention because she was cross-examining the witness. The state objected to what the question was, and the judge said, to the extent that you're comparing yourself to a religious, whatever he said, you can go ahead, right? I'll overrule. So it's even that, the point that she's trying to make, the comment that you're comparing yourself. If we look at the transcript of the trial, she clearly was comparing herself to Nephi and also comparing Alex to Nephi. But oh my God. She's trying. She's trying. I mean, I guess if she tries enough, even a broken clock is right 2 times a day. Maybe one day she'll get something right. But yeah, I thought that was interesting, and I just wanted to follow up from her last hearing with Judge Boreski on that. So they started jury trial or jury selection on Friday. They stopped it. So this hearing was in the morning, pre-jury selection, and then they ended up going home early, and there's rumors and speculation that Lori might have COVID or something else. I think she was exposed to someone who might have it, and so they alerted her because the judge said if you end up being quarantined, right? So they'll probably go back and test her. And if she has it from being exposed to someone else, then they will quarantine her. And he asked her to let them know. But what do I know? That's just my 2 cents, as usual. Thank you for coming to hang out with me. I appreciate you. I will talk to you later. Toodles.